speak to him now. John outlined lots of issues there, didn't he, for the government? But why don't we start with that one? Letby refusing to come up into the courtroom from her cell and saying that she's determined not to come up on Monday for her sentencing, causing huge distress, yet more distress for the families.
Well, that's right. It's the ultimate final insult that is being administered by this mass murderer to the families of these innocent victims. It's adding insult to the massive injury that's been caused. And of course, this will be a process not just where the judge will explain to the defendant the crimes and the gravity of the crimes, but for the victims' personal statements to be read into the record, introduced into the court, so that the wider world understands the full devastating impact of these atrocious crimes upon so many grieving families. And that's why I think it's right that we do everything we can to stop this sort of behaviour from becoming a trend. We've seen far too many of these cases recently, and that's why the government is right to act, and it should be acting as soon as possible to change the law.
I suppose the issue is that no judge wants a defendant to be dragged kicking and screaming and being violent towards prison officers, because that's not really going to be conducive, is it, to how a court works? But you have another solution.
Well, my solution would be to avoid that sort of scene from developing and from, in effect, the defendant once again getting control of things, to have a live link into the cell with the sound and video on, so that the defendant has no choice. They have to hear what's being said, and the judge and everybody in the court will be confident knowing that as they speak, this is being broadcast to the defendant, who literally has no place to hide. That, I think, could be a compromise solution for now. I think the government is right to look carefully at the options here. In a case like this where, you know, the sentence is yet to be passed, but it will be, I'm sure, one of the, you know, a very, very steep sentence indeed under the life sentence provisions that will apply for murder. There will be cases where perhaps an extra factor, you know, contempt of court or an additional sentence could be added, which would then reflect the non-cooperation of a defendant and their refusal to face up to the consequences of their actions.
Yeah, a campaign continued after the death of Olivia Pratt-Corbell, that little girl shot dead last year on Merseyside. So we know that the government thinks this is a good idea, and yet we seem to be a long way from it being legislated for.
Well, the government have got the Victims and Prisoners Bill currently going through the House of Commons. It's going to come back for further stages later in the year. That's an opportunity, I think, for the government to act. I think that legislation does take a bit of time. It will take many months. That's the way it works, and rightly so. But the government does have this vehicle and this opportunity to do something about this. I know that's what the Lord Chancellor wants to do, and I'm confident that he and the Victims Minister, Ed Argar, will be working very hard on this issue in the weeks ahead.
Let's talk about another issue. The judge in this case, Mr. Justice Goss, who, having seen quite a lot of this trial, I think has handled this case with incredible skill and sensitivity. He did put a court order on the naming of all the victims and indeed their families. What was his reasoning for that, and was it the right decision?
Well, look, Mr. Justice Goss is an extremely able and experienced criminal judge who I know well, and I think we can all have confidence in the ability of his decision-making in what was the most complex of cases. I think, however, the general point should be made, and I'm sure the learned judge was very alive to this, of the principle of open justice and the need for the wider public, through the media, to know the full extent of what happened here so that it can be explained. I think one of the issues, one of the challenges now is understanding precisely what happened, which of course is really important for any inquiry, the public inquiry that will happen, so that the full extent of not just the course of conduct here, the criminality, but the response of the authorities as well to that can be understood. This is why the courts are, I think, rightly reluctant to interfere with the principle of open justice. And my hope is that this case doesn't somehow set a precedent where you see people saying, well, I'm a bit embarrassed, I'm a bit, worried about giving evidence. That isn't a good enough reason for there to be reporting restrictions applied. It needs to be a much higher threshold. Indeed, the Act, the Section 46 of the 1999 Act, does set out things very clearly, and it is a higher threshold. But I think it's right for all of us to reflect generally on the imperative of open justice, so that we can all understand what has happened here, and public confidence can be increased in the integrity of the legal process.
Yeah, you've talked a lot about open justice and transparency. Where do you stand on cameras in court? We know that the law has changed, and we're now seeing sentencing taking place on camera, and indeed I understand that will happen on Monday. But shouldn't the whole trial nowadays, in this modern era, be on camera as it is in America on the whole? Isn't it time for that, rather than reporters trying to report that trial, relying on those hand-drawn pictures?
Yeah, I mean, I'm glad and proud to have been the Lord Chancellor that worked with the judiciary to allow the televising of sentencing remarks in the Crown Court, and that, I think, has been a big advance. All of us, members of the public, journalists, can then see the precise reasons why the judge has imposed the sentence, and of course things, if they're explained, things can be understood much better, and we avoid the sort of headline chasing hue and cry that sometimes happens after sentencing. My view about the trial process is that we have to be very careful about what we do and what parts of the trial could be televised. I think, putting the camera on the jury would be wrong. I think unduly focusing on the defendant or other people in the dock or members of the public, I think, would be wrong. I think we need to do some more careful thinking about whether parts of a trial can be shown, not necessarily as a live link, but certainly to help understand, the process and the detail of the evidence. I think more work needs to be done, but I'm certainly not against moving away from, as you say, the artist's impression, which doesn't necessarily give the public the fullest flavour of the solemnity of proceedings and, in fact, the quality of the work that is done by counsel, by solicitors, and indeed by trial judges.
And just finally, I want to talk to you about the public inquiry. This case has been utterly horrific, and we've heard from a number of consultants who tried to blow the whistle and yet were ignored. At least one of them, Dr. Ravi Jairam, saying today that he wants a public inquiry, a full public inquiry, rather than an independent inquiry. He's right to be calling for that, isn't he?
I think he makes a very powerful case. What we've got to make sure is that the nature of the inquiry is not just independent, but it has powers to summon witnesses and to receive documents in a way that, for example, we're seeing with the COVID inquiry. We've got to make sure that the tribunal, the inquiry chair, has got those powers so that everything is out there in the open, and that we can, first of all, improve the position of whistleblowers. There's no doubt more work has to be done there, but also change the culture within not just the NHS but public institutions more generally, from one of a defensive position, always worrying about litigation and being defensive, to a more open culture where mistakes are going to be made, but with early action mistakes can then stop becoming disasters or tragedies or atrocities such as the one we see in this case.
Yeah, certainly the themes we're hearing over and over again are openness and transparency, which is always good to hear. Robert Buckland, Conservative MP and former Justice Secretary, thank you very much indeed.